Now, my assignment, as I understand it, is to talk about some of the dynamics of high-profile cases. And what I'm going to tell you this afternoon is not anything that you probably haven't already thought about yourself, probably don't already know. It may or may not be helpful to be reminded of some of these things, however. And it's also true that I'm going to be speaking largely from a judge's perspective, but I'm going to try to tease out some lessons that I think lawyers should be cognizant of about such cases and some of the dynamics of such cases for two reasons. Number one, because it may be helpful in their own practices, and number two, it's always helpful for a lawyer to have some idea of what's going on behind the bench, and what some of the thoughts are and some of the pressures are that are brought to bear on a judge in a high-profile case. Now, in the past, when I've given talks on high-profile cases, I've usually followed the introduction with a slide, PowerPoint slide, pointing out that high-profile trials are not new. They've been around for a long time. And so the first slide is almost invariably the trial of Socrates. These trials have a similarity over the years. I don't have a PowerPoint here today, but it is important to point out the observation that we're not talking about anything that's new, or basically anything that's different. It's been around for a long time. There are certain cases for particular reasons which pique the public's interest, or which generate the public's interest. And they run the gamut. The public interest may stem from a whole variety of different sources. It may have to do with the public's interest in the issues that the case involves. This was certainly the situation with the Proposition 8 case and the National Security Agency cases that Judge Vaughn mentioned in the introduction. It may have to do with the celebrity or notoriety of one or more of the trial participants. This was certainly the situation in the Barry Bonds case that my former colleague Susan Ilston tried very recently, and which I'll talk about a little bit more in a few moments. And I really don't need to remind you of some of the names associated with those kind of trials. Casey Anthony, Anna Nicole Smith, Lindsay Lohan, Robert Blake, Michael Jackson, Scooter Libby, Kobe Bryant, Martha Stewart, Ron Blagojevich. These names, of course, we all know simply because they were involved in certain cases, and those cases that involved those individuals attracted a high profile. And it may have to do with some exceptional nature of the proceedings that generates the public interest. The gubernatorial recall litigation of a few years back, the reapportionment litigation in the 80s, I was involved in that as a lawyer. That attracts a lot of public attention and a high profile. And it may have to do, because of the particular nature of the issues involved, I think of the immigration case that Judge Susan Bolton in Arizona recently tried, or the log cabin Republicans case challenging the don't ask, don't tell policy that Judge Jenny Phillips in Southern California tried. And it may have to do with the outcome of the case, or the anticipated outcome of the case. For example, in the Oracle merger case that I was assigned several years ago, and the Apple-Microsoft case involving the graphical features of the Windows interface, it was thought that the outcome of those litigations would affect people's jobs, employment opportunities with particular companies, and indeed the fate of certain companies. And I think it's fair to say that that assessment is correct, and that that generated public interest. Public interest that's generated in one of these kinds of cases can be quite different, one kind of case from the other. But there are certain similarities that kind of run through all of these cases once the case reaches a certain high profile. We also know that for the most part, what we do as lawyers, judges, does not attract a lot of attention. It's not high profile. It's of interest, of course, to the parties. It's of interest to the lawyers. Usually, we hope it's of interest to the judge. Occasionally, it may even be of interest to the juries. But for the most part, we don't have to deal with the problems associated and that are peculiar to those kinds of cases where there is intense public focus on the case and the participants. So, as there are various ways in which public interest in the proceeding tends to shine a light in ways that are atypical of most litigation, the vast bulk of our work does not attract that kind of attention. And it may very well be that we as judges and lawyers may slip occasionally into habits or activities or a frame of mind that's more attuned to trying a case in the relative serenity and privacy of most courtrooms than it is in a case that's full of reporters that has the intense light of public interest and attention drawn to it. And there's another aspect of high-profile cases that we should bear in mind in thinking about what lessons are to be learned from these. It's important to remember that the public interest in high-profile cases is sometimes very fleeting. It is almost invariably superficial, and it is frequently ill-informed, and on occasion, even motivated by an intent to disrupt or in some way to contaminate the proceedings. So with that background, let me tease out, if I can, 4 lessons that I think should be helpful to judges and lawyers in dealing with such cases. Lesson number 1, lower the temperature. A judge charged with handling a high-profile trial needs to be firmly in control of the proceedings, and the lawyers should do nothing to disrupt that judicial control. No matter the irritation and the heartburn that some lawyers inflict on the judge, and believe me, lawyers do inflict heartburn on judges from time to time, a cool judge goes a long way to setting the right atmosphere in the case. And no matter the irritation and heartburn that some judges inflict on lawyers, and some judges indeed inflict heartburn on lawyers, lawyers ill-serve their clients, and they ill-serve the administration of justice by trying to take control of the courtroom. The judge should be in control of the courtroom, and actually that is beneficial, not just for the judge, not just for the appearance of the proceedings, it's beneficial to the orderly disposition of the litigation. And the best way, I think, for the judge to lower the temperature is for the judge to do the job that judges are there to do, setting a reasonable but firm schedule and sticking to it. Look at the example of Judge Ilston in the Barry Bonds case. That was a case that had all kinds of distractions. A major distraction, maybe even the principal distraction, being the interlocutory appeal that the government pursued from one of Judge Ilston's evidentiary rulings, which delayed matters and created the opportunity for a lot of additional publicity and all kinds of distractions associated with the case. Judge Ilston never let any of that interfere with her efficient handling of the case. She ran the trial when it finally came to trial with a minimum of fuss and upset. And at no point did she lose her cool. She ruled on motions promptly, held a number of case management conferences with the lawyers to deal with logistical issues, and when the case was finally back in her courtroom after the detour to the Ninth Circuit on the interlocutory appeal, and ultimately an unsuccessful appeal, she set a firm but sensible schedule and held to it. When the trial started, it ran like a well-oiled machine. Judge Ilston selected the jury in less than 1 day. A marked contrast to the distended jury selection process that we've seen in some other cases.